Hi everybody, welcome back to the 10th of an hour with Griffin Bridgers. For today's episode 22, we're going to tackle a controversial subject. We're going to look at the 3 common estate plan structures for married couples. Now in all of this, I want to emphasize that I'm not perpetuating the myth that estate planning services are commoditized, because estate planning involves advice, and advice is never commoditized. It's always tailored to a client's situation. Really, what we want to emphasize here is that these are common estate plan structures for certain clients who are at the top of a bell curve in different situations, usually around estate tax planning. Now, importantly, I want to emphasize, too, that this presentation is not intended to serve as legal or tax advice. Now, the most common and basic type of plan is what's known as sweetheart wills. Now, under this type of plan, at first death, everything would go to the surviving spouse, typically outright by will or by beneficiary designation or otherwise. And the intent is that the surviving spouse at second death will leave the combined value of the estates to children in equal shares. Now, the gifts to the children, or the distributions to the children, can either be outright, or they can pass in trust until a certain age, or they could even pass in trust for life. Now, we'll look at some of the issues on that later on, but with all of the different types of plans we're going to look at, we can assume that the default nowadays for a lot of drafting tends to be that shares for children will be held in trust at least until a certain age, instead of being distributed to them outright. One problem with this plan, though, is that it forces the children to wait until second death to get anything, and it leaves the spouse in a situation where he or she would have to make gifts to the children, potentially subject to gift tax during life. So to avoid that and to use some level of estate tax planning, there's another option called the disclaimer trust. And what this does is it emphasizes that through certain types of elections, including the portability election, that maybe the estate tax exclusion of the first spouse to die can be preserved through some form of trust planning and some form of estate tax election. But the default in this type of plan is that everything once again goes to the surviving spouse, but usually it will be in the form of a marital trust, which limits the surviving spouse's access to those assets, but makes sure that those assets are held for the sole and exclusive benefit of the surviving spouse as well. Now, for estate tax flexibility purposes, the surviving spouse has the option to also use some of those assets through a disclaimer or otherwise to fund what's known as a family trust. And the difference with the family trust is that the spouse and children and descendants can be beneficiaries of that trust. Now, both of these trusts are like a light switch when you come to making this election. Anything in the marital trust typically will be taxed in the estate of the second spouse to die, and will use that second spouse's estate tax exclusion, including any amount preserved through a portability election here, whereas anything in the family trust will use the estate tax exclusion of the first spouse to die. And then finally, at second death, the combined value of the surviving spouse's estate plus marital trust and family trust will be divided into equal shares for children. The third type of plan, this is typically for one or both spouses who might have a taxable estate for estate tax purposes. This is what's known as the AB trust type of planning, where at first death, an amount of the first spouse's estate up to the estate tax exclusion amount, currently $11.58 million, will fund a family trust for which the spouse and descendants may be beneficiaries, and any amount over and above that exclusion amount would pass into a marital trust for which the surviving spouse is the sole beneficiary. And when this is done right, it ensures that regardless of the order of death, the estate of the first spouse to die will not be subject to estate tax. And then ultimately at second death, estate taxes will be paid, if any, at that time, and then what's left of the surviving spouse's estate and the family trust, and if any, the marital trust, will be divided into equal shares for children. Now, outside of any plan that involves a family trust, one problem is that kids don't get anything until second death. So to avoid that, one common customization is that you can make specific gifts, maybe at first death or second death. This could come in the form of direct cash gifts or just unequal divisions of the estate, but it's important to make sure that they're not duplicated in each plan. Typically, when this is drafted, it's done in a way where it's only under the documents of the first spouse to die or the documents of the second spouse to die. You can also give some flexibility through a power of appointment. Now, typically the power of appointment will provide flexibility in administration and not in taxation. So you want to avoid giving a general power of appointment to a spouse over the family trust or even over the marital trust, because it reduces the ability to make some of those tax elections and maximize the estate tax exclusion. If there's a residence going to a spouse, it's typically better to title that in the marital Q-tip trust. Oftentimes that's titled jointly, which can override the estate plan, as noted on the next point, where beneficiary designations and titling need to be checked, as we've emphasized in last week's episode, to make sure that they are consistent with the flow of this estate plan as well. So instead of naming a spouse as beneficiary, you could name the marital trust as beneficiary. Now, the choice of trustee is important. Now, you can also let the spouse be trustee of the marital trust and family trust, and even let children be trustees of their own trust. But there can be tax issues involved if the ability of each beneficiary to make distributions to themselves as trustee is not limited to an ascertainable standard like health, education, maintenance, and support. If you give them the unlimited ability to turn on the spigot, that could cause them to become the owner of those assets for estate tax purposes, which could run contrary to the tax planning benefits and intents of these types of plans. And also, especially with children, if they are trustees or have the ability to name a trustee at a certain age, that could reduce the creditor and divorce protection inherent in their trust, because the entire intent of leaving assets in trust to a child instead of outright is to provide some protection against themselves. So those benefits could be lost depending on which state they're in or which state the trust is created in. So it's important to be aware of those issues as well. So to reduce these, you could always use an independent trustee or a corporate trustee when appropriate, but that could come with its own set of fees and also with a little bit more red tape to receive distributions from the trust. So that's it for today's episode of the 10th of an Hour. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. Thank you again for listening, and I look forward to seeing you in the next episode.